But here to join me now is State's Attorney Patrick Keneally from McHenry County. And I wanted him on because there was this interesting article in the Sun-Times titled, "With the End of Cash Bail, Dramatic Increase in Appeals from People Ordered Held in Jail or Told to Submit Restrictions to be Released." So the Illinois Supreme Court actually announced this week that they had to create a task force to study the issue and report back to the state's highest court because they had been inundated with appeals of people who have been held in jail that want to argue that the Safety Act says that they should be let out of jail. Patrick Keneally, thank you for joining me tonight on The Real Story.
Thank you so much for having me, Jeanne.
So could you add a little bit of more insight and context to this for us laymen?
Yeah. Well, this is like the biggest self-inflicted wound from the Supreme Court as well as the Appellate Court. So now that they're being overworked, the Safety Act appears to be a problem. But when it was just sort of the safety of the community that was at stake, there was no task force that was formed. But you know, if you think about how criminal laws used to be passed, and you well know because you were in the state legislature, there would be sort of this idea or this vision for a criminal justice bill, and they'd get the State's Attorneys Association, they'd get the Public Defenders Association, they'd get the Judges Association, they'd get the Chiefs Association, they'd get the ACLU, and they'd put them in a back room, and they'd say, all right, you guys, like, this is sort of the sketch of what we want to do. Can you guys sort of come up with a way that's going to make it work and sort of be digestible within the system? But if after George Floyd and in the wake of George Floyd, when sort of the Black Caucus made this Faustian deal with Madigan and they were sort of given the keys to the kingdom, they put in the back room the ACLU, the Public Defender's Office, and then all of their activist friends who had just graduated from their, institutions of indoctrination, and they had these hearts full of purity and empathy and faux outrage and righteous indignation, and they created the Safety Act. And the underlying theme of the Safety Act is just an obsession with trying to get criminals out of jail by any means. And so they've created these inordinary rights for defendants, and one of them is that the state immediately and with very little time to prepare has to have a hearing as to whether or not we're going to be able to detain you on those detainable offenses. And it's this long, sort of tedious, complicated process, which I said the state has very little time to prepare for, and then it creates an automatic right to appeal if the person is detained. And so now in the 2nd District, which is the appellate court to the west of Cook County, and in the rest of the districts, there's 5 appellate districts in the state of Illinois, they're seeing up to 80% of the appeals being of these defendants who are being detained pre-trial, and they're getting bogged down.
Meanwhile, these defendants, they're public defenders probably for the most part, so this is creating a lot more expense as well because you have an automatic appeal if you get detained.
Yeah, and it's a complicated process, and the state has such a high burden. So we have this burden of like clear and convincing evidence, which is the step right below reasonable doubt. But they're doing it to themselves. Like the one group that had the opportunity to probably stop the Safety Act was the judges. So at the time, it was a time of like McCarthyism, if you recall, in 2020, right towards the end, and states attorneys and police officers were pushed to the side, but the judges still had the legislator's ear. They swallowed the whistle for the Safety Act, and they knew it wasn't going to work because they had a 2020 report that came out on pretrial fairness where they said that the state was not ready for cash bail. So they didn't want to get run over by the woke train at the time, so they sort of stepped aside and let this bill pass. And now it's a major problem. But another problem is that they're represented by the public defender, and they want to appeal it. So the public defender is going to come up with some basis to appeal, but they're validating a lot of these frivolous claims that are going up on court. So there was a case in the 2nd District just last week, and it was out of McHenry County. We had a drug dealer, all right, who was selling a Class X, that's the highest amount of crack cocaine. The police officers nearly essentially witnessed this guy selling that amount of crack cocaine. He's got an extensive criminal history that goes back 30 years, and the appellate court says that, well, the state hadn't proved that the person was a danger to the community. And I'm thinking to myself, like, this is the biggest layup in the history of layups. Like, this is an absolute no-brainer.
So
and if you're going to sustain these types of cases, you're going to get a lot more. And the truth is that if this guy applied, let's say, to the 2nd District or to one of these appellate courts and was like, look, I want to turn over a new leaf and I want an internship, they'd shudder at the thought. If they saw this guy in the street, they'd cross over to the other side of the street. They'd be a fool not to. And yet, for these frivolous reasons based on just cavilling and sophistry, they're allowing these people out, and so now we're just encouraging more and more appeals.
Okay, hey, can I hold you over this break? I have something more to discuss with you on this.
Yes, of course.
Okay, very good. We'll go on a break. We'll be right back.
The Real Story with Jeanne Ives continues on AM 560. The Answer.
Okay, thanks for joining me tonight. We still have State's Attorney Patrick Keneally from McHenry County on the line with me, and we were discussing this this issue with all these appeals coming up from folks that are sitting their butt in jail because they violated the law, and they want to say that the Safety Act says that they should actually be out. And so you had just told us about this, a Class X, a drug dealer, essentially with a 30-year record. Now let me get that straight. He did win on appeal, or it's up for appeal?
He did win on appeal. So
he won on appeal.
So they said that. So he won on appeal. So he was dealing a significant amount of crack cocaine. He had over 30 arrests. He was sentenced to the Illinois Department of Corrections in 2020 for delivery of a controlled substance, which is basically drug dealing. At some point, he got out, and now in 2024, he's found dealing drugs again. And the appellate and so the trial court in McHenry said, just based on this person's history and based on the nature of the offense, he's a danger to the community. It goes up on the appellate court, and they say that the state has not proved by clear and convincing evidence that he's a danger to the community, because just sort of a general threat to society is not enough.
So when the Safety Act was first passed, I specifically recall, though, that drug offenses, nearly all of them, were non-detainable. Am I right? And then there was like 4 different amendments that came in after the Safety Act because it was so bad to begin with. And so he's apparently still in that classification where he could have been detained.
So a Class X drug offense is a detainable offense by virtue of the fact that you have to go to prison if you're found guilty of it. So all offenses where you have to go to prison if you're found guilty of it are detainable offenses. But you're right, it's still a major problem because there are certain drug offenses like possession of fentanyl, possession of meth, possession of crack cocaine, certain delivery of those types of drugs that are still probationable in smaller amounts, and those are non-detainable offenses.
Okay, well, this is the time where I'm just going to add in a little 2 cents here, and that's the fact that the DuPage County Chairwoman Deb Conroy sponsored and voted for a bill that would decriminalize enough fentanyl to kill 1,500 people. And along with her were a number of other state reps, including State Rep Maura Hirschauer. Good job, West Chicago, for electing her. But I just want to get my 2 cents in since you brought up fentanyl. But let's turn to another topic here. Chicago. Here's a headline from Breitbart. Chicago organized retail burglary ring allegedly led by newly arrived illegal aliens. And it goes on to talk about, the Chicago suburb of Oak Brook's been beset with an increase in retail theft and burglaries. So what are you seeing in McHenry County, or what do you know of from, other areas around you in terms of illegal aliens and whether or not they're getting, involved in a lot more crime?
Yeah, so one of the things that people don't realize is the criminal justice system is the most disaggregated form of government that there is. And so the criminal justice system in McHenry County, in DuPage County, looks very different from the criminal justice system in Cook County. The people who are least informed of this point are many of the people that are committing crime. So they come to places like DuPage, or they come to places like McHenry County, and they commit these types of organized crime, whether it's retail theft or otherwise, thinking it's a non-detainable offense, but also, and which it is, but also thinking that, that this is sort of one of the offenses that isn't, let's say, quote unquote, a priority for Cook County, which means that they're just going to either plead it out for something small or dismiss the case. So a lot of times they'll come up here and they'll commit these crimes, and they'll realize that there is going to be sort of this staunch response that they're not expecting and not ready for. And that's exactly the type of message that we're seeing. But of course, yeah, the thing is that to presume that especially organized crime is not sophisticated and is not aware of some of the nuances in the law that allows them to operate with impunity, especially with regard to pretrial release, and that they don't think about that when choosing what types of crimes they're going to commit, would be wrong.
Yeah, they're just as savvy as, I mean, they're more savvy than actually the people who own the retail stores. Quite frankly, they know exactly how to make the hit, how much they can steal, and then they can be let off. There's no doubt about it. Now, the other thing that I was curious about is you've got Orland Park just passed an ordinance basically saying, look, we're not a sanctuary city. We're not going to act like a sanctuary city, and you can't find sanctuary here if you enter the country illegally. And there you see a lot of other sort of places putting in busing ordinances and trying to make sure that people are not just randomly dropped off. What's your opinion of some of this stuff since, we were made a quote unquote sanctuary state in 2017?
Yeah, I think, I think that, again, like you have sort of the heartbeat or the engine of Illinois politics, as well as the ideas coming out of Chicago, and the rest of the state is just sort of being dragged along like a dog being pulled by somebody on a bike. But I do think that many of these ordinances, especially the busing ordinance, are going to run up against some serious constitutional problems. I think that while they're not facially prejudicial against a suspect group, I do think that in practice they probably are. I think the clear intent is to keep immigrants out. They are a protected class. And by virtue of that, I think the United States Supreme Court or federal courts are going to begin applying strict scrutiny. So you saw that the Texas Bus Company filed a lawsuit against Cook County for a similar busing ordinance that's been copied by many other municipalities as well as counties. I read the complaint, and they got some pretty good points. So not only with respect to equal protection, but also with respect to preemption. So the legal doctrine of preemption means that when the federal government has occupied sort of a field of law, states cannot come in and supplement that, nor local governments can come in and supplement that. And so what that means is that they occupy the field, and all other laws are just going to sort of fall by the wayside. And I do think that's how the United States Supreme Court is going to interpret it when it gets to that point. Now, in the short term, these ordinances are in place, and I'm sure they're slowing the transport of many of these migrants up, which may be what the municipalities want. But in the long term, I don't think they're going to stand.
Okay. Wow. I really appreciate your expertise on all these topics. You're just a breath of fresh air because you just lay it out there for us common folk to understand. And before we leave, I wanted to give McHenry County Republicans a shout out. They have a big Lincoln Day dinner on February 17th, and their guest speaker is Steve Moore. So you can go online and find tickets and get out there. Patrick, thank you so much for joining me tonight on The Real Story.
Thank you for having me.